Today we're going to look at the landmark Supreme Court ruling that makes it illegal for employers to fire employees simply for being gay or transgender. Hey, welcome to the channel. My name is Nate, lawyer turned YouTuber. Today we're going to talk about the landmark case, Bostock v. Clayton County, Georgia. This case is going to be taught to lawyers in law schools for generations. Let's get into the facts. 17 states allowed a person to be fired if they were gay or transgender. In a 172-page opinion, the Supreme Court found that the term sex in Title VII of the Civil Rights Act of 1964 makes it illegal for employers to discriminate against employees based on a person's sexual orientation or transgender status. Now first, let's start with the law. The 1964 Civil Rights Act has probably had the greatest impact on employment nationwide. Now, Title VII prohibits discrimination of employment based on race, sex, and religion. Now, this act revolutionized the labor market. Now, it gave both women and minorities opportunities that they wouldn't have had if this discrimination was allowed to stay legal. Let's look at the constitutional authority that gives Congress the authority to pass such legislation. Now, I know this is going to be shocking, but most people automatically go to the 14th Amendment and believe that this anti-discrimination legislation is under the 14th Amendment Equal Protection Clause. But it is not. This particular title of the Civil Rights Amendment of 1964 was passed under the Commerce Clause. The Commerce Clause is found in Article 1, Section 8, and it simply allows Congress to regulate interstate commerce amongst the states. Now, the reasoning why Congress can pass such anti-discrimination laws under the Commerce Clause is that employment is an economic activity within the states, and that can be regulated because it has an overall effect on interstate commerce. People move and travel between states to work. There are people here in New York who come here from New Jersey. So since there is this connection to interstate commerce, Congress is allowed to pass regulations and laws regulating that particular commerce. Now, the question in this case that the court had to deal with is, what did the term sex mean in the 1964 Civil Rights Act? And did it cover members of the LGBTQ community? So this decision is a combination of three cases. The first is from Clayton County, Georgia, where employee Gerald Bostock was fired from his job as a child welfare advocate for conduct unbecoming. What was that conduct? He joined a gay softball league. The second case was out of New York. Skydiving instructor Donald Zarda was fired days after mentioning to his employer that he was gay. The last case was out of Michigan. Funeral home worker Amy Stevens was fired after she told her employee that she would rather be identified as a woman. And this was 6 years into her employment. Before we get into the legal arguments, understand this. Both parties agreed and conceded that the term sex in the 1964 Civil Rights Act referred to the biological distinctions between men and women. So let's talk about the arguments. Well, first, the opponents. They took an originalist perspective of the statute. Originalists generally believe that statements in the constitutional law must be interpreted based on the original understanding of the authors and the people at the time it was passed. So we're talking about 1964 America. So the question is, what did Congress mean by saying sex in 1964 America? Let's just be honest. They didn't mean LGBTQ. Opponents said, rightfully so, that the bill was debated in Congress and the protections for the LGBTQ community were specifically rejected. Now, there is some nuance here because it was well known that it was hard to get this 1964 Civil Rights Act even passed. There was a filibuster for like 50 days. And adding protections for the LGBTQ community was thought as to be a poison pill. If you add that, then the bill wouldn't pass at all. So opponents said, we'll just pass the bill as is and leave out those protections. Remember, we're talking about 1964. Their core argument is one that I am sympathetic to. It says, if the court can add legislation to what Congress had rejected, then the court essentially becomes a super legislature. This violates the separation of powers, and the court is essentially writing the laws. But now let's look at the other side. The other side argues a more progressive view. The law is an evolving document, and it needs to change over time. Examples would be like the freedom of the press, where at one time we were only talking about those big printing presses. But now that is extended to online media, television, and that is way outside the scope of the original context of what was going on. And the argument was by the plaintiffs that this is discrimination based on sex, even if you leave out the interpretation. Why? Because simply, if you have a man that's attracted to another man, then he would be able to be fired. Then if you have a woman who's attracted to a man, she wouldn't be fired. And the only distinction between the two scenarios is the gender of the person. So obviously, this would be discrimination based on sex. So, which side had the stronger argument? The originalist argument that says, hey, this was argued and rejected, or the counter argument that this was discrimination based on sex, and this is what the law was meant to stop. Justice Neil Gorsuch writes for the majority, an employer who fires an individual for being homosexual or transgendered fires that person for traits or actions it would have not questioned in members of the different sex. And therefore, he said, the employer is in violation of the Civil Rights Act. So the court's rationale for its reasoning isn't that they're changing the term sex from what it was understood in the 1960s, but that this discrimination is discrimination purely based on sex. And that if it's discrimination based on sex, the law clearly doesn't allow it. So, I gotta pass it to you. What do you think? Do you agree with the originalists where, hey, in 1964, they said this did not encompass transgendered and gay individuals, and now the court is adding that to it? Or are you more convinced with the court's reasoning that this is discrimination based on sex? I'd love to hear what you say in the comment section. Now, if you made it to this point in the video, please like, share, and subscribe if you haven't done so already. If you feel so inclined to do, please support the channel, grab a channel membership, join Patreon. As always, my name is Nate, lawyer YouTuber, and I'm gonna check you later. Peace.